We have it, ladies and gentlemen. The U.S. government strikes back at Workhorse. We have got the actual motion to dismiss the case from the government, and we're going to go through that. I've highlighted all the details. I've read through the entire motion, and it is going to be interesting. Excuse me for that interruption. Okay, so what we're going to do is we're going to dive into the motion itself, but real quick, what I want to start off with is a timeline of events, so we're all caught up and on the same page. And there's some important dates to mark on your calendar because, ladies and gentlemen, we should know whether this case moves forward or is this case going to get dismissed before summer is up. All right. So first off, if we look at, let's swap this around for just a moment. I'm going to put up on the screen the time of events. Okay. So in our last video, we left off and we were talking about the dismissal. Okay. The motion to dismiss from the government and also from Oshkosh Defence. These two red highlighted areas here. So the motion to dismiss from the U.S. government, the USPS, had no dismissal rule attached. We have that now. However, that sealed motion from Oshkosh Defence did list two rules. Rules B, 12B, 1 and 6. Lack of jurisdiction and failure to state a claim. So what we did in our last video is we went through the Workhorse complaint, which let me pop that up here. This is the Workhorse complaint. We went through this complaint and we looked for anywhere that mentioned jurisdiction, which on page 5, section 13, this mentioned jurisdiction. Okay, we went through this, and then we went through the summary starting on page 1. We went through the highlights, the summary of everything Workhorse claims the USPS did. And to sum it all up in just a few words, the Workhorse alleges the USPS said, well, in the very beginning, before taking any applications, that the process was already, what word could I use? The outcome was already secured before any applications had already come in. That's the gist of what Workhorse is saying. And there was a lot of shady allegations made against the USPS that just, to me, it just stinks. And I'm not a lawyer, so I can't say for sure. But we're going to go through a little bit of the motion here from Workhorse, the complaint from Workhorse. But what we're going to start with first is a timeline. So let me pull the timeline back up. All right. So the timeline. We're going to go through a very quick recap of the timeline to get everyone caught up and on the same page on the Workhorse v. United States USPS complaint protesting the award of the Next Generation Delivery Vehicles contract that was awarded to Oshkosh. So this all starts, this lawsuit, it all starts on June the 16th. On June the 16th, Workhorse filed a sealed 59-page complaint against the United States USPS protesting the award of the Next Generation Delivery Vehicle contract to Oshkosh Defence. The court set a date, and this is a date that everybody needs to remember. August 16th, 2021. This is when the court set a date for an answer due date. So by August 16th, 2021, we should know whether the case moves forward or whether the case gets dismissed. Okay, on the same day, still on June 16th, 2021, the complaint was randomly assigned to Judge Zachary Summers. So we know who the judge is for the case. Also on June 16th, all of the lawyers involved for both parties, both sides, filed their notice of appearance with the court. There was also an unopposed motion to intervene filed by Oshkosh Defence. Basically, that allows Oshkosh to come to the defense of the United States, the USPS, in this example. Okay, now we move on to June 17th. This was a busy day for Judge Summers, as he was making a bunch of schedules. He had a closed conference call / video call with all parties involved: Workhorse, the USPS, Oshkosh Defense, and all their attorneys. As for the scheduling, the government had until July 6th, 2021 to file a motion to dismiss the case, which they did file a motion to dismiss the case on on July the 6th. The next scheduled date is July 20th. This is the date which is the deadline for Workhorse to file a response to the government's motion to dismiss the case. So when we get to the actual motion that the government filed, the USPS filed against Workhorse to dismiss the case, we're going to see what they're claiming and why they say the case should be dismissed. Workhorse then is allowed to respond to that, and that response is due anytime between now and July 20th. Okay, the next date is July 27th. This is the deadline for the government to file a reply to Workhorse. I know, it's crazy, right? How our judicial system works. But anyways, after that, the judge then makes his decision. And it's all based on, as you will see, two words. Those two words are prudential and mandatory. Okay? Prudential and mandatory. The Workhorse v. United States USPS case in the beginning right here is going to come down to two words: prudential or mandatory. Prudential means that Workhorse was allowed to skip a process step that the USPS had laid out, and we're going to get into what that was, and go straight to the court. So then the case would most likely move forward if the judge rules prudential. If the judge rules mandatory, that means that Workhorse could not skip that step before going and filing with the courts. Then the motion to dismiss will probably be upheld. So that's going to be very important. All right, the last thing done on June 17th is that Workhorse filed applications for access to protected material. This is like the discovery phase in a normal court case, but you're limited in the scope for which you can ask for information. Next up is June 18th, and that's when Oshkosh Defence filed applications for access to protected material. Same thing that Workhorse did. Then we get to June 28th. Workhorse files its complaint with redactions. Workhorse's complaint that they filed, I'll pull it up, is right here. Okay? This is the complaint that Workhorse filed. 59 pages, and they make a lot of claims about what the USPS did, all alleged, of course, because we haven't been to court to resolve any of these. All right, the next date is July the 6th. July the 6th, as scheduled, the United States, the USPS, filed a sealed motion to dismiss the case. At that time, the reasons were not made available to the public. Also on July 6, Oshkosh Defense filed a sealed motion to dismiss the case, citing Rule 12B1 and 6, which are lack of jurisdiction and failure to state a claim. So in our last video, we had that information. We did not have the actual motion. Here we go. We did not have the actual motion to dismiss the case. We have it now. It was released late on Friday. Yesterday, I went through, read it all, and highlighted the important parts. We are going to go through that. Then we get to July the 9th, and we're just about done with the dates. July 9, Workhorse filed applications for access to protected material. This is so they could take a look at the motion to dismiss from the government because it was sealed. That means nobody but the judge could look at it. So Workhorse had to make a request to look at it. Okay. On July, just looking at my timeline notes that I wrote down here, July 9, the court released a redacted version of the motion to dismiss the case to the public. That's what we have now, and that's what we're going to go through. The United States, USPS, filed a 23-page motion to dismiss the case, citing rules which was the same as Oshkosh Defense, 12B1 and 6, lack of jurisdiction and failure to state a claim, citing the same rules as Oshkosh, like I mentioned. This motion to dismiss was brought on by Workhorse, who filed a 59-page complaint protesting the award. We know the rest of that. All right. Okay. Here's what it comes down to. Let's go through this real quick here. I'm going to make it a little bit bigger. Hopefully it's a little easier to see here. Okay. All right, so let's get into motion to dismiss. Now, the first part of this, they have their table of context. And then we get to table of authorities. Excuse me for 1 minute. Table of authorities. The United States, the USPS, lists 28 different cases where the court ruled in favor of the United States in similar circumstances, similar situation as we are in with Workhorse. They also list a few statutes, regulations, administrative material to the court, and all of that information is going to be used in different parts of their motion to dismiss the case. So, in this motion, defendant's motion to dismiss the case, pursuant to rules 12b1 and 12b6, the rules of the United States Court of Federal Claims, as well as the court's June 17, 2021 scheduling order, and that this is why we went through the timeline, because different dates are brought up here. Defendant, the United States, respectfully requests that the court dismiss the complaint for failure to exhaust administrative remedies. Administrative remedies. The United States wants this case to get dropped. They want this case dismissed because of a technicality. As you would expect, since this is the beginning phases of the lawsuit, any and all of Workhorse's complaints that they mention in here are not being addressed. They are being completely ignored because the government does not want to reveal any information before they have to. That is why they are only trying to dismiss the case right now based on a technical error. All right? So let's get back into this. Introduction. As we all know, on February 23rd, the United States Postal Service awarded a contract for producing the next generation of mail delivery vehicles to defendant intervener Oshkosh Defence. An unsuccessful offerer for the same contract, which is the plaintiff, Workhorse, disagrees with the USPS's decision, but Workhorse filed this action without fully exhausting the administrative remedies established by the USPS. USPS regulation states that judicial review is not available under these circumstances. Okay, this is wow. So all the complaint that Workhorse laid out, and I believe Workhorse laid out a tremendous case. The government wants this dismissed on a technicality, and we're going to get into what that technicality was in just a moment. They continue. This motion presents two related questions. Can the court dispense with the exhaustion requirement in the Postal Service's regulations? And if it can, should it do so here? So this exhaustion requirement right here, this exhaustion requirement, this is the technicality the U.S. Postal Service is trying to use to get the case dismissed. All right, the first question should begin and end with the Federal Circuit's binding decision. The court should held that Where a regulation requires exhaustion, a party's failure to exhaust administrative remedies precludes judicial review of its claims. So the U.S. government says that since Workhorse skipped the last step in the USPS's required exhaustion for the administrative remedies, because Workhorse skipped that last step and went straight to judicial review, that the case should be dismissed automatically because of that technicality. The government goes on to say, Workhorse has indisputably failed to exhaust administrative remedies required by applicable USPS regulations. As a result, the court must dismiss this case. All right, so we understand that. Now, the second question, they only pose two questions. The second question, to the extent it remains relevant after the court resolves the first, should likewise lead to dismissal. The Supreme Court has identified a limited set of circumstances in which trial courts may excuse a party's failure to exhaust some types of administrative remedies, but none of these circumstances are found here. So what the government is saying is that, first and foremost, the case should be dismissed because Workhorse skipped one step, just one step. So the case should be thrown out. But if for some reason the judge doesn't see it that way, and remember, it comes down to two words: prudential and mandatory. Okay? Now, if the judge does say, okay, well, the first one is okay, I agree with Workhorse, then we get to the second question, and that is, can the court even do it? Because the Supreme Court has precedent. Well, maybe. All right, let's keep reading and see what the government has, what else the government has to say. Okay, so we just said none of the circumstances are found here. To the contrary, requiring Workhorse to strictly comply with the USPS's exhaustion requirement would promote judicial efficiency and protect the USPS's unique authority over procurements. So the government is saying Workhorse failed to go through the USPS's exhaustion requirements because Workhorse skipped one step. One step. That's it. This all comes down to a technicality. All right. The government goes on to say, even if the court has the discretion to excuse Workhorse's non-compliance, it would be imprudent to exercise that discretion in this case. The court should accordingly dismiss the complaint. Wow. The government is basically arguing the case should and must be dropped due to a technicality. That's just something. All right, questions presented. Number one, and there's only two. Whether the complaint must be dismissed because Workhorse failed to exhaust mandatory administrative remedies. And we're going to get into there's a two-step process that Workhorse needed to go through according to the USPS. Workhorse only did step one and skipped step two. So we're going to get into whether that's really what happened or not by looking at Workhorse's actual complaint too. All right, question number two. Alternatively, if the administrative remedies at issue are prudential, rather than mandatory, whether well-established exhaustion principles counsel in favor of dismissal. There's those two words I mentioned earlier, prudential and mandatory. If the judge agrees that the USPS's two-step process for filing a complaint is prudential, then the case will most likely continue to move on. But if the judge rules that the two steps to redeem a problem was mandatory, then the case will most likely be dropped and the government will win on the argument of technicality. All right, next on the motion to dismiss, we get to the statement of the case, rules and regulations governing postal service procurements. So what the USPS here is going to set up their independence from the government. Congress designated the Postal Service as an independent establishment of the executive branch of the government of the United States. This label symbolizes a legislative desire to have the Postal Service, quote, run more like a business, end quote, than the predecessor Post Office Department. So in history, the USPS used to be part of the government. Now it's not exactly. It's indirectly. But they did this. They broke the post office away to be more independent so it could run more like a business. Well, any business run this way, losing all these billions of dollars, wouldn't be in business much longer. Okay, but that's irrelevant to the case here with Workhorse. All right, the government continues. Congress passed several statutory provisions to ensure the USPS's independence in the procurement arena. So the USPS has independence to hire, fire contractors at will, okay? They are authorized to do that. It authorized the USPS to, quote, make such expenditures and to enter into such contracts, agreements, and arrangements upon such terms and conditions and in such manner as it deems necessary. Okay. Other than a few exceptions not relevant to this protest, Congress provided that, quote, no federal law dealing with public or federal contracts shall apply to the exercise of the powers of the USPS. Do not govern USPS procurements. Okay. So remember after the contract was awarded and members of Congress were upset and publicly stated that this was the wrong decision the post office made. They should have went with an electric vehicle company, that going with a internal combustion engine setup is wrong when we're trying to be more clean energy and responsible for our environment. Well, the USPS is saying here, Congress, thank you for your comments, but they don't matter. We're independent. We can make our own decisions. All right, moving on to what the government continued to say. The USPS's purchasing regulations establish a mandatory two-step administrative process for resolving disagreements. Now, this is the most important line to understand. And what happens next is very important to understand. Excuse me for just a moment. Okay. This two-step administrative process for resolving disagreements. Workhorse did step one. Workhorse did not do step two. Instead, went straight to a judicial remedy. USPS is saying since they skipped step 2, the case should be thrown out. Again, the case thrown out on a technicality. Here's the first step. Disagreements must be lodged with the responsible contracting office in writing. And the USPS, I'm sorry, Workhorse did this step. We know they did this step. They put this step in their own complaint that they did it. Okay. Disagreements concerning the award of a contract shall be lodged within 10 days of the date the supplier received notification of award. Workhorse did that. Within 10 days, Workhorse filed that disagreement. Moving on, the government continues. Once the contracting officer receives a disagreement, she has 10 days to resolve it and communicate with her resolution. Okay, this happened. Workhorse said so. So let's just hop over to Workhorse's argument and let's do a little. Okay. All right. So here's Workhorse saying, all right, let's get to it real quick. Okay, where is it? Where is it? Okay, here we go, right here. This is in Workhorse's complaint. This is item number 75. Shortly thereafter, Workhorse submitted a good faith disagreement to the USPS in accordance with their rule, triggering a 10-day resolution period in which the USPS is required to attempt to resolve the disagreement by mutual agreement. In its disagreement, Workhorse requested that the USPS withdraw the award to Oshkosh and make a new award decision based on a rational best value analysis. Best value comes up a lot. During that 10-day period, however, the USPS made no contact with Workhorse at all, much less any effort to come to a mutually agreeable resolution. Instead, the USPS spent the resolution period authorizing a lengthy, screened, aggressively attacking Workhorse and its years-long effort to assist the USPS in developing its first-rate next-generation delivery vehicle. The USPS delivered its scorched earth resolution decision to Workhorse on the evening of the 10th day, March 22nd, 2021. This is the response letter. So if we go back, okay, if we go back, this is what the USPS is talking about in their motion to dismiss. Okay, now this is something that's highlighted blue here. Listen to this. Long ago, quote, the Court of Federal Claims has jurisdiction over all government procurement protest cases, including those involving USPS. The reason this is mentioned is because Workhorse cites this exact case, Emory Worldwide Airlines, the United States, If we go back over to the Workhorse complaint and we type in airline, here we go. This is when Workhorse was talking about the court having jurisdiction. They mention right here, Emory Worldwide Airlines versus United States. This court has jurisdiction to consider this action because it is, quote, a claim that the government breached an implied in fact contract to fairly and honestly consider an offerer's proposal in the procurement context. And they list two different cases as precedent to why the court has jurisdiction. All right. All right. So that's why in the USPS's motion to dismiss the case, they have this mentioned in here. They're basically saying that long ago, the Court of Federal Claims had jurisdiction, but they no longer have jurisdiction because we are independent. All right. The government goes on to say, and this is again about the two-step process, okay? If the disagreement is not resolved within 10 days, or if the supplier is unsatisfied with the contracting officer's resolution, the supplier must move to step 2. Okay. When Workhorse got the resolution letter, they were not satisfied. Okay. If we hop back over, I wish there was a better way to do this instead of hopping back and forth. I hope you're able to keep up. Okay, so in here, if we go to the okay, so let's see. We need to get to okay. All right. So remember what I read here, the 10-day period, the USPS delivered its scorched earth, quote, resolution decision to Workhorse on the evening of the 10th day. Okay. The response letter revealed that the USPS had identified numerous purported, quote, critical deficiencies in Workhorse's proposal that it had not previously raised or otherwise indicated as award prohibitive during discussions. For example, while the USPS letter claimed that redacted, we don't know what it is, neither of those concerns were described to Workhorse during discussions, nor did the USPS inform Workhorse that it considered its service plan unacceptable. So Workhorse says that the USPS came back with this letter 10 days later, like they were supposed to do, and said to Workhorse, well, you needed to fix this, or you needed to fix that, or this was wrong, or that was wrong. And it was the first time that Workhorse says was ever brought up. It was the first time it was ever brought up. So we don't know. But that's what Workhorse is talking about when the USPS is also talking about this first step. So after 10 days, after step 1, if the problem is not resolved, then we move to step 2. Okay, here's step two. Step two, which exists in part to expedite resolutions and reduce litigation costs, is, quote, the sole and exclusive means to resolve disagreements under, and they have a code here. In this step, the aggrieved supplier must lodge a second disagreement with the Supplier Disagreement Resolution Office, SDR office. This is the step the government says Workhorse did not do. And for that reason, the case should be dismissed. Let's see what the government had to say now. This is still about step two. The SDR official must then establish a time frame for resolving the disagreement and promptly gather all necessary information and issue a written decision. Okay, so that's saying what the SDR official must do, all right? The default time frame for resolution by the SDR official is 30 days. So after step one, you have 10 days to file. Once you file a disagreement, the Postal Service has 10 days to respond. The Postal Service respond not in a favorable way that Workhorse thought. So Workhorse, instead of doing step two, went on to file a complaint with the courts. So this is what the government, the USPS, is saying. The case should be dropped because of a technicality, because Workhorse skipped one step. All right. The government goes on to say the SDR official has broad authority under the Postal Service's purchasing resolutions. Notably, the purchasing regulations make clear that this two-step administrative process must be fully exhausted before a protester can seek judicial review. The USPS's final contract award may be appealed to a federal court with jurisdiction. Okay? All right. Now we get to the next generation delivery vehicle procurement and Workhorse's disagreement. And again, there's a lot of information here. I've only highlighted the important parts. Okay, first up from the government, 6 prototype suppliers, including Oshkosh and Workhorse's former partner, VT Hackney, were selected. Now, I concluded in our last video when we were looking at Workhorse, and let's just hop back over to Workhorse's complaint, and let's go closer to the top. Right here, this redacted area, this is Workhorse's complaint. Workhorse, together with its former partner, redacted, spent 6 years and over $6 million designing, prototyping, and refining a proposed next generation delivery vehicle. I thought, and you can see my notes right here, I thought this redacted name was VT Hackney out of Washington, North Carolina, and that's exactly who it was. So at least one of my redaction predictions was correct, as VT Hackney is Workhorse's former partner. But they did split ways early on in the process, okay? Well, this process took many years, nearly a decade, so They split after about 6 years or so. All right. The next thing the government says, the USPS committed to selecting the awardee based on the best value to the Postal Service. There's that word again, or phrase, best value. I mentioned this earlier on the Workhorse complaint, best value. So an internal combustion engine versus an all-electric vehicle over the lifespan of the vehicle, according to the Postal Service, has the best value. The internal combustion engine has the best value. Okay. Even though the entire U.S. government wants all fleets, including an executive order from our president, that the U.S. fleet should be zero emissions as soon as possible. But as Workhorse pointed out in their complaint, the USPS never had the money to go with an electric vehicle anyways. So, not even sure why they let Workhorse go as far as they did. Okay, the government continues. On February 23rd, 2021, the Postal Service notified all offerers that it had decided to award the next generation delivery vehicle contract to Oshkosh. This decision was based on a determination that Oshkosh's proposal offered the best value to the Postal Service. On March 12th, Workhorse lodged a disagreement. 10 days later, March 22nd, the contracting officer issued a detailed response letter denying Workhorse's disagreement. Workhorse never lodged a disagreement with the SDR official as required. Okay. As required. It comes down to these two words. As required. Is that prudential or is that mandatory? That's what Judge Summers is going to have to decide. Could Workhorse skip that second step and go straight to the courts to get relief? Or did Workhorse have to follow the USPS's guidelines and follow through with step 2? The government continues. On June 16, almost 3 months after receiving the contracting officer's response to its disagreement, Workhorse filed the instant protest. During a telephonic conference held the following day, the court permitted the government to brief one threshold issue before addressing the merits of Workhorse's allegations. Now listen to this. Should the complaint be dismissed because Workhorse failed to exhaust applicable administrative remedies? For the reasons that follow, the court should answer that question affirmatively and dismiss the case. Okay? Then we get to the argument. In considering a motion to dismiss for lack of jurisdiction, the court usually assumes that all factual allegations in the complaint are true and draws all reasonable inferences in the plaintiff's favor. However, a plaintiff cannot rely solely upon allegations in the complaint if the defendant or the court questions jurisdiction. Instead, the plaintiff must bring forth relevant, adequate proof to establish jurisdiction. Excuse me for one moment. Okay. Let that sink in for a moment. Does the court have jurisdiction? If the defendant, the government, USPS, charges that, hey, wait a second, the court does not have jurisdiction, as long as they issue that in their motion to dismiss, all of the complaints from Workhorse, okay? Starting at the top, protesting the award, saying that the USPS conducted the procurement in accordance with applicable law, the solicitation requirements, and fundamental fairness, Workhorse would have been awarded the contract. Workhorse spent 6 years, $6 million designing prototypes. USPS never had any intention to fairly consider Workhorse for the award. USPS put its thumb on the scale against Workhorse, falsely blamed Workhorse's prototype safety incident when it was actually a USPS driver's error, completing the initial design in only 1 year and building 6 prototypes in a mere 18 weeks. The announcement of a $3.1 billion contract, not a $6 billion contract that we saw all last year from many different places. It was only a $3.1 billion contract. Surprising not just to Workhorse, but to members of Congress, the media, and other observers, us retail investors, that the USPS went with an internal combustion engine and may only produce 10% of vehicles to be electric or hybrids. In stark contrast to UPS, FedEx, Amazon, DHL, which are aggressively moving towards all-electric, zero-emission fleets. The USPS attempts to defend its decision on cost grounds. Electric vehicles have a significantly lower total cost of ownership, outweigh the additional cost of charging infrastructure. Yes, with electric vehicles, charging infrastructure would need to be built, but Workhorse had a plan for that. Completely unlike the Ford Transit base prototype. Yes, Workhorse puts in their complaint that Oshkosh vehicle the USPS had selected for production was entirely different than the vehicle Oshkosh had put forward in the prototype phase. The vehicle that Oshkosh put forth in the prototype phase was a Ford Transit with a custom body on top. That's not what Oshkosh submitted as the final production vehicle. USPS had selected a vehicle from Oshkosh that skipped the prototype phase altogether. So, the reason I'm reading through all of these complaints by Workhorse is to show that as long as the government brings up a question on does the court have jurisdiction, then none of these complaints can stand. The judge cannot listen to, read about any of these complaints if a jurisdiction challenge is brought. And that's what the government did. The government, in their motion to dismiss, is based on, whoa, the court, you don't have jurisdiction. We do. We make the decision. But right here, if Oshkosh Defense allegedly is allowed to skip the prototype phase altogether, then Workhorse skipping one little step 2 of a two-step process, well, shouldn't that be allowed? Shouldn't that be fair and equal? I'm not a lawyer. These are allegations from Workhorse. They are not fact held up in court. They have not been judged on. But you make your own decision. What do you think? Okay. So let's continue with what the government is saying. To avoid dismissal for failure to state a claim, a complaint must allege facts plausibly suggesting, not merely consistent with, a showing of entitlement to relief. In other words, the facts as alleged must be enough to raise a right to relief above the speculative level, on the assumption that all of the allegations in the complaint are true, even if doubtful in fact. A bunch of legal jargon that basically says, was Workhorse harmed by not getting this contract? Answer that question. Was Workhorse harmed by not getting this contract? If Workhorse was harmed, then at that point, and if it can be proven by fact that Workhorse was harmed by not getting the contract, then the allegations can be brought forward. However, they say right here, speculative level. Is the harm to Workhorse real or speculative? Meaning, if Workhorse got the contract, versus if Workhorse did not get the contract, not getting the contract, what harm did that provide to Workhorse? This is what the government is saying. And the government is saying there was no real harm to Workhorse for not getting the contract. There was only some speculative harm done to Workhorse. But in the Workhorse complaint, we're going to get to the bottom of this, and we're going to see what Workhorse wants for relief. And does it line up with factual or is it speculative? When we get there, you let me know. Okay, then we get into, it is undisputed that Workhorse failed to exhaust applicable administrative remedies. The government is just saying the same thing many different times and in different ways, okay? Their argument is Workhorse skipped the second step. Therefore, this case should be dismissed. All of that, everything I have highlighted here, it is only one argument. One argument. Workhorse skipped the second step of the USPS process. Therefore, the case should be dismissed on a technicality. Okay? That's what this whole dismissal thing, this whole motion to dismiss is all about. All 23 pages worth. That's it, man. That's it. Okay, so I don't think I'm going to get into any more details on this because, again, I'm probably boring you, because in the motion to dismiss, the government is just continually saying the same thing over and over again, but in different ways, bringing up different past suits, different past cases to try to bring their point home. That you can't skip a administrative process and go straight to court. Okay, so what does Workhorse want? What does Workhorse want? It's real simple, honestly. Right here, this is in Workhorse's complaint. This is their request for relief. This is what Workhorse wants the court to do. Okay? Workhorse respectfully requests this court to enter judgment in plaintiff's favor and to provide the following relief. 5 things. All right, 5 things. Number one, Number one, entry of judgment in favor of plaintiff and against the United States, USPS. 2, entry of a declaratory judgment that the award to Oshkosh was unlawful and improper, and an injunction directing that the award be terminated. Number 3, entry of an injunction directing the USPS to reevaluate the offeror's proposals in accordance with the terms of the solicitation, applicable laws, and regulations. Number 4, entry of an injunction directing the USPS to conduct a new best value determination. And number 5, such order relief as the court may deem just and proper. Workhorse is not requesting a lot of relief, to be quite honest. But this is in the hands of Judge Zachary Summers, and he has until August 16th to provide answers. Okay? Now, let me just remind you of the important dates that we need to watch for. The first one is July 20. Okay? July 20, Workhorse, it's the deadline for Workhorse to file a response to the government's motion to dismiss the case. So that motion should take what the government is saying, the reasons the government wants the case dismissed. Workhorse will be providing a response to that dismissal and giving their reasons why the case should not be dismissed. Lack of jurisdiction, failure to state a claim. Those are the 2 reasons the government states for dismissal. So Workhorse needs to respond to those 2 motions. Okay? And that's on July 20. After that, July 27 is when the government responds to Workhorse responding to the government. The judicial system. All right. Now, after that, after the deadline of July 27th, then at that point, the court, Judge Zachary Summers, will make his decision on whether or not the case will move forward or the case is going to get dismissed. It's really that simple. And according to the date the judge set, or the court set, of August 16th, that means the judge potentially has from July 27th until August 16th to make a decision. It can be before that, but I don't think it can be after that. So let me know down in the comments the dismissal of the case, lack of jurisdiction, failure to state a claim. The government, their argument so far is that the court does not have jurisdiction because Workhorse failed to go through step number 2 in their 2-step process when there's a disagreement. And since there is a jurisdiction question in play, the failure to state a claim, the allegations that Workhorse have made against the government, the USPS, are not relevant at this time because of the jurisdiction question. So, right now it's in Judge Zachary Summers' hands. It's up to him what he's going to decide to do. We're going to watch this closely. Again, our next date is July 20. We should have something from Workhorse. July 27, we should have something from the government. And then August 16th, we should have something from the judge. Those are the important dates to watch for. Okay, I hope you found some value in this video. If you could help me out, it would be greatly appreciated. Smash the like button. Share this video far and wide, okay? Let everybody know what the court is doing, what the government is doing. And also subscribe so when information comes out on July 20, July 27, and August 16, you will be among the first to know about it. Thank you so very much for watching, and I will see you in the next video.